Okay, now I'm going to introduce Brent Turnbull from Cornwalls. Brent's going to give an overview around understanding your rights in the construction industry when insolvency strikes. I'll hand over to you, Brent.
Thanks, Penny. Appreciate the time to speak to your members. Now, if we could just flick forward, I've got a slide that I just want to use as a starting point in relation to this, or can I control the screen? No. Summer, can you just flick forward to my slide for me, please?
I think they've put it onto one slide, onto this slide.
Oh, hang on, here it is. Sorry.
Yeah.
Help. I'm so used to seeing my own livery. I apologise. Okay. Look, I've got 15 minutes or thereabouts here, so I'm going to blow through this a bit quickly. But there's going to be a question and answer at the end, and frankly, I despise chalk and talk, so I'd rather anybody who's got a question ask it. Can I start with the fact that this is an important topic for not just plumbers, but for everybody in the construction industry, and it's frankly just not something that we've managed to solve as yet. There are a lot of big promises that have been put out there about solving insolvency in the construction industry, its impact up and down the line, but it hasn't been achieved yet. So we need to look at it on that basis. Now, the first thing I want to talk about very quickly is administration and liquidation. Usually it's a result of poor journalism, not understanding the difference, but there is a difference between the two. So if you're the victim of either one, you need to understand what the differences are. Put it to you this way. Administration is what happens when a company thinks it might be insolvent, that is unable to pay its debts as and when they fall due. And the idea of administration is you call in an administrator, and the administrator then sees whether or not they might be able to trade their way out of the potential insolvency. Importantly, what it does is it creates a moratorium on doing nasty things to the company and its assets during that period of time. Liquidation is basically the company in its death throes. You call in a liquidator to basically gather in the assets of the company, get rid of as much as they can, and pay people what they're entitled to under the rules. Now, liquidation is invariably far worse for people further down the line, because liquidation generally involves the secured creditors, that is the banks who have mortgages and things like that, and people who have charges over various and or all aspects of the company enforcing their charges, taking away the assets of the company, and then the poor old unsecured creditors, like people who are owed debts by the company, are left at the back of the queue, and they might get to share in some money, at some stage in the future, although that invariably doesn't happen. So the most important thing you can do when there's potential insolvency floating around is to try to get yourself higher up the chain. It makes you it gives you a better priority in terms of trying to get at the money that you might or might not be owed. Now, there's a number of ways you can do that, and I just want to speak very quickly about those now. The two that are particularly relevant beyond getting things in your contract and getting things registered on the Personal Property Securities Register, and I'll talk about that a bit later, are the Subcontractors Charge and what I like to refer to as the Adjudication Charge. Now, if I flip those over, the payment claim or the Adjudication Charge, when you're a subcontractor, you won't run into that very often. But I do want to emphasise on the off chance that you might occasionally, because people are using more construction management methodologies now than traditional principal contractor subcontractor arrangements. You will find times where you are contracted directly to the principal. If you're contracted directly to the principal and you have an adjudication that you've been successful on, you haven't been paid, there is a potential for you to register a charge over the block of land on which you're doing the work. Now, there's some technicalities around that, but it's important, because if your head contractor or your principal go broke in that set of circumstances, you've actually got a charge over the actual asset that you're doing the work on, the land. So it actually puts you in a better position in terms of potentially getting paid. Now, you might be behind a mortgagee or something like that, but at least it puts you in a better position than being an unsecured creditor who is unlikely to get paid at all. The one that's probably more important from your standpoint is the Subcontractors Charge. Now, that's been rolled into the Building Industry Fairness Act in 2017. But for those of you who remember what a subbies charge does, basically, if you think about the traditional contracting methodology of principal, contractor, subcontractor, what happens is the subcontractor is owed some money by the contractor. So what the subcontractor does is it serves a notice on the principal and says, well, to the extent that, Mr. Principal, that you owe any money to your contractor, they owe me some money as subcontractor, so I want you to hold that money in place while we sort it out with the contractor. Now, that sounds good in theory, and it will give you a charge over the money that's potentially due and owing. That can be a little bit better in theory than it is in practice, because often when there's insolvency floating around, the letter that comes back from the principal to you as the subby is, well, that's nice. We don't owe them anything because, as you may have noticed, they've just gone broke and we have a lot of claims against them for defective work that hasn't been completed on time, and so on and so forth. On top of that, it also means that you have to commence proceedings to what they call enforce the charge, and you have to do that within a month of service. Now, you can solve a bit of the dollars issue in relation to that by potentially clubbing together with other subcontractors, or alternatively, what you can do is you can just file the proceeding and then just stick it in your back pocket. You have a year to serve a proceeding. But what you can do is you can serve your charge, file your proceeding, and then basically just sit there and see how it all shakes out without having to spend too much extra cash. The advantage of the subbies charge, as I've said, is it gives you some security over money coming down the line, rather than, again, just being rather than just being an unsecured creditor of a company that's just gone broke and clearly won't be able to pay. The next thing that I wanted to talk about that's sort of coming up in my inquiry line at the moment is material and equipment. People are really concerned about what to do if they have somebody go broke. Can they just go on and get their stuff? Well, probably so. If you set yourself up, and a lot of this stuff is setting yourself up beforehand. I mean, I can go on for hours about how you can contract to deal with insolvency. But there's a couple of things I want to drive home. What you need to do, you need to make sure that when you're on site, when you take stuff on site, if you get the impression there's going to be an insolvency, don't bring all of your plant and equipment on site. Generally speaking, you'll be able to get it off, but it can be a bit of a pain in the backside, and a liquidator can take up to 21 days, 28 days to determine what they want to do. So that might not be a great answer for you if you're sitting there with a whole bunch of material and stuff in situ. But there's some things you can do contractually in terms of it, and I think it's a good idea to have a good think about this. A lot of people will have retention of title terms on the back of their invoices. Don't stick them on the back of your invoices. They don't work. It's no good giving somebody a retention of title clause after they've ordered the product and the contract's been entered into it. What you need to do is you need to have a standard set of terms and conditions that include rights regarding your retention of your property and who owns it. Now, can I just pause there for a second and make this point? If you put the stuff if you've already installed it in the property, it ain't yours no more. It's not a chattel. It's become actual part of the land. You can't go out and rip it out. I've had one glass contractor have the go and try to rip glass out of a premises where someone went broke. They got themselves in trouble. The best example I can think of is someone who tried to rip out electrical wiring associated with the NBN. He got charged in South Australia. He got himself in a lot of trouble. So don't go rip stuff out unless you own it. The important part that I need to emphasise, though, is, and it's not well understood necessarily at the subby level, is when you have stuff that's sitting on site that you might have parted with possession of. This is the traditional retention of title. Traditional retention of title is I've given you something, but you don't own it until such time as you pay me. If you have that in your contracts, you need to have that registered under what's called the Personal Property Securities Register. And if you don't, then when the liquidation happens, the liquidator will own the stuff. That's not particularly good from your point of view. Registration on that register is about $20 per registration. It is an absolute lifesaver. If you want to talk about that in due course, please let me know. I'm very happy to go into detail about it. I've got some very good guys here who do that.
Is that $20 per item?
Per registration. If you register, like say you've got
a bobcat and an excavator. And...
yeah, you register all at the same time. Equipment is a little less problematic than material. Material is the one that freaks people out, in my experience. But needless to say, you need to be a bit careful about your equipment too, because done wrongly, you can lose your equipment. Happened in WA in a case called Forge, lost $20 million worth of excavating equipment. I can tell you the people involved weren't particularly happy. Next question is, what do I do with the people who are below me if I have suppliers myself and subcontractors? The best I can tell you at this stage is you need to sort that out contractually, because you can't just not pay people. You're in a bit of an unfortunate position. There really isn't much you can do except try to sort it out. Most importantly, that's why you need to make sure that you can get your stuff as quickly as possible from site, because at least you might be able to go and do something else with it rather than being sat in a bit of a holding pattern for 21 days, which would be significant for any small business. Some general issues relating to liquidators and insolvency. I see too many subcontractors. Now it's just the nature of the business. I've said this to liquidators, and this has been run in court as well, that it does the industry no credit, but unless you chase debts in construction, you don't get paid. Unfortunately, it's just the way the business works. Liquidators don't understand that. And because they don't understand that, you will find if you've been paid an amount in the 6 months before the liquidation commences, you are going to get a nasty letter from the liquidator saying, give us the money back. It's a preferential payment. In order to assist you with that, there are some things you can do. Apart from, if you get a letter like that, get legal advice. Doesn't matter who you get it from somebody who knows construction. I'm not advocating one person or another in relation to that, but go and get some, because there are some technical answers that you can make if you get a letter like that. More importantly, just because the liquidators demanded it or said it doesn't make it true. There are a number, unfortunately, the way people word letters doesn't help them sometimes. May I recommend to your members that if you are going to write letters to people, do not use words like insolvent, broke, unable to pay your debts. If you use any of those, the liquidator will fasten onto you and it'll be very difficult to deal with them. So just make sure that you're asserting your rights. They might come after you anyway, but at least you'll have a better chance you're not going to get tripped by your own wording. The other thing about it is go and get legal advice, because dealing with the liquidator is a technical exercise. And frankly, put it to you this way, and Rita is going to hate me, who are the people that deal with liquidators, but you need to understand that liquidation to some degree is an old adage, is a bit like the old adage, always back the horse. That's called self-interest. The first person to get paid in a liquidation is the liquidator. So the more money the liquidator gets in to pay his own fee, the more money available to pay the liquidator. So you can often use that to cut deals with them and things like that. So you need to really think about what you're doing, and it's a good idea to have somebody like a lawyer have a look at this sort of stuff, so we can be a bit of an independent and sort of cool head when these sort of issues arise. Apart from that, that's a very quick encapsulation of what I wanted to say. It's a much bigger topic than that, naturally.
Yeah, thanks.
And said, I appreciate fully the problems of this industry, and unfortunately, it's one you've really just got to start managing your business on purpose, I like to say. It is worthwhile going out and getting your contracts looked at from a how do I manage insolvency in terms of my contracting. And it's also worthwhile going out and having a look at things like trade contract insurance and those sort of things. They can be insanely expensive, but look, at the end of the day, insurance isn't a bad idea for some of this stuff, because at the end of the day, the industry is hierarchical. I don't think there's any way to get away from it. No one's come up with a perfect solution that insulates everybody if something goes broke, particularly if someone goes broke in the middle, like a contractor. So you just have to protect yourself as best you can and continually run your business on the basis that how much credit am I prepared to extend to people who haven't paid me and things like that. I think that's the take home from it.
Thanks, Brent, for providing an overview. I think that was very useful information. Just when you were talking in relation to the liquidators, one of the questions that came through was in relation to that preferential payment. What happens if the plumbing contractor's already spent that money? Like, does a liquidator sue the plumbing contractor for those funds? Like, what would the process be? I know you obviously said get legal advice. Yeah.
Look, the answer is this. The process looks something like this. To answer your first question, it doesn't matter if the plumbing contractor has spent it. It doesn't matter. It's a preferential payment. They're entitled. If it's a preferential payment, the liquidator is entitled to it back. What's the process in terms of that? Well, the first thing you'll do is you will get a letter from the liquidator that says something which will just literally say, you have been paid this amount of money. It was within 6 months of our appointment. We consider that to be preferential. Ergo, give us that amount of money back. That's the first. You might get a letter that there's a little bit more detail than that. It might go into your correspondence and things, but that varies, depends who your liquidator is. Usually the answer to that back to the liquidator is, well, you assert those things, but we had no idea the company was insolvent, or we have no reason to suspect they're insolvent. What we suspected is they were just being jerks, because that's the way the industry is. So we kept hammering away. We had no idea they were insolvent or anything like that. So you write something like that, you say, what's the basis upon your assertion? You'll get a letter back usually. And then what you can do then is generally you can cut some sort of a deal with the liquidator. And I can tell you, it's generally a pretty favourable deal in the construction industry. And often you can pay over some time because the liquidator is very keen to get some dollars in, and because they want to pay themselves, frankly. So if you can put together something that looks sort of vaguely sensible and isn't over forever, liquidator has to get approval if a deal is more than 90 days in duration. So if it's less than 90 days and you can put together something very basic, you'll often cut the deal. I mean, I'll give you an example. I acted for a plumber in relation to one of the liquidations happened a couple of years ago with a very aggressive liquidator. And I wrote a letter back to him like that. And I think the preference was allegedly about 150 and we settled for 15, paid over 3 months or something like that. So 5,000 a month or something. So, I mean, it wasn't great, but it was better than the 150 that was allegedly owed.
Yeah, that's good outcome.
And they can, and if you don't pay and you can't cut a deal, they can sue you, and they will sue you. And the worst problem is they will have some firm of solicitors, because you've got to remember, liquidator isn't getting paid unless he gets some dollars in. A lot of the firm's solicitors who act for liquidators will act on spec, which means they won't get paid unless there's an outcome. So it's not as if you can even, just sort of drag things out a bit and, make them feel the pain of some costs, because they're not paying any. So I always recommend seeing if you can cut a deal early on. At least you can look yourself and your spouse in the eye often, rather than trying to get involved in litigation.
Yeah, that's a good idea. The next question is, if a plumbing contractor is aware, or if there are rumours going around about a particular builder in trouble, and there's a few rumours going around at the moment around individual builders that industry's talking about, are there any implications to them receiving payment in reference to preferential? So if you're aware of XY builder that might be in trouble, are you in any breach or anything at that point?
Oh, look, what you subjectively know is what you subjectively know, is I suppose my answer to that question. In terms of, I always think it's better to accept to accept the money and have the argument about it later. My view of the world is always don't put things like that in writing. For example, if Jeff tells me down the pub that somebody might be in some trouble, well, I mean, what does Jeff know other than he hasn't been paid? What they have to prove is that you have to have a suspicion that they were insolvent. And as I said, in this industry, then there's case law, at least from South Australia, that basically endorses this approach. Is generally you would say, well, no, I didn't suspect they were insolvent. I suspected they were being jerks. And I can tell you from years in the industry that companies who are insolvent are hard to get money out of, as well as companies who are flush with cash. They're just difficult, some people. And just because somebody's told you down the road that they think they're not getting paid because the bloke hasn't got any money, well, how do you know that the reason they're not getting paid is because they've just done a dodgy job?
True.
I mean, you don't know any of these things. That's why it's better off not to indulge in too much wild speculation, particularly in writing.
We've seen this. Some builders have recently put out, you may have heard rumours in the industry. Don't worry, we're perfectly fine. You've got nothing to worry about. I mean, that's quite a bold statement. That's
why Condev is just such a different beast. They put out almost the opposite statement. They said, I think we'll be fine if we get some dough.
Support from the developers.
Yeah, but just seemed to be a very different scenario than the one you usually see, which is, as you say, builders saying, no, we're flush with cash. What are you whinging about?
Yeah. Okay. One of the other questions that come in, and you mentioned it before in relation to the trade creditors insurance. So if a plumbing contractor was doing work on a particular project and they decided that it was, potentially a risk for them in terms of maybe getting paid, that they decided to put in place trade creditors insurance. I understand it can be quite expensive, but are they still entitled to be paid if they have that trade creditors insurance, or is it dependent on the insurance in the specific insurance company that they use?
Depends upon on what your insurance coverage is. Entirely dependent upon the terms of the policy, and from when you're insured to the specific types of insurance that you have, for what you get paid and for what the exclusions are. For example, they're not going to take out, they're not going to take a policy of insurance related to Condev, for example. There'll be something in their policy about when your insurance kicks in. And more important than that, as most of them, as I understand it, are basically work on a contractor by contractor basis. There are certain contractors they just won't insure. If you want to do work for them, your policy doesn't respond.
That's obviously a risk. Sorry, that's obviously a risk that each business would need to assess if that's what they chose to do.
Oh, look, that's right. There are certain other bodies who've said if they won't insure them, don't work for them. I mean, that's ultimately it's a commercial decision for people to make as to whether they want to do it or not. But I mean, taking the conservative view, and particularly in the current market, if the insurer won't back them, then you'd have to give some thought to whether you want to be involved or not, I would have thought.
Yeah, of course, especially if perhaps you might have one job with a builder and then they're offering you potentially two more. Do you want to take the risk as a business to perhaps, have a lot of your work with one particular builder? Because obviously if they did go into liquidation, it would be a massive risk on your business, especially if you didn't have the trade creditors insurance in place as well. This
is the old, what I was saying before about doing your business deliberately. And part of that is potentially the old adage of not putting too many eggs in one basket. Because the reality is, and we've all seen it, construction companies go very fast. 1 minute you think they look fine and the next minute, bang, they're gone. So it's very difficult to keep a track of them. So when you're sort of playing a bit of, close misère with the other team and you really don't know what their finances are, you probably need to be having a look at, do I want to be exposing myself entirely to one company?
Yeah, definitely a commercial decision for individual businesses. Yeah.
Mm.
Sorry, I've got two more questions. The first one is, in a situation of ConDev or ProBuild, does QBCC have the power to audit those subcontracting firms who were impacted? Will they be looking at the creditors list and then potentially targeting them to provide updated financials? And do they actually have the power to do this?
Look, I think the answer is they potentially could, I think, but I suppose the practical point is I don't think they're going to, for at least the following reasons. One, I've never seen them do it in the context of a collapse. Secondly, it would be absolute political suicide for whoever was sitting in the commissioner's chair, because nobody wants to start auditing subbies who've just been kicked as a result of a company going broke. And probably the third one is also they just haven't got anyone over there at the moment. It's not like QBCC 10 years ago when they had a massive audit team. They just don't have those sort of resources anymore. So the reality is they have to target it. And I don't think subbies who've just been kicked in the teeth by ConDev and ProBuild going broke are number 1 and 2 on their list.
Yeah, okay.
Just to follow up to that, Ben, I spoke to one of the
not that I
members.
speak for QBC.
No, I just thought I'd ask the question.
No, I was just caveating that.
Yeah, no. Sorry.
Sorry, Ken, I apologise.
No, you're right, Brent, all good. I spoke to a member probably 2 weeks ago doing some calls, and he said to me that he had a bad debt from a builder that he wrote off, and because that jeopardised his financial position and changed his MFR, they did refuse it. They held up his contracting licence until he sold some assets and replenished his MFR to get back to the level they wanted him at.
Did that come as just so I understand, Kent, because I'm always interested in hearing other people's experiences.
Yep.
What was that? What triggered the MFR? Was there an audit that they'd done of him, or what was the trigger?
I believe his MFR the year before was fine, and then he went to fill it in for the following year. Went for the following year, and because he'd written off a bad debt to a builder, it put his cash flow down a little bit. Still owned everything, still travelling fine, paying everyone, everything was fine. Guys were getting paid, subbies were getting paid, suppliers were getting paid, but because he didn't get to the ratio that they wanted for him to have his level of license that he had to sell assets to get back to where he was. And he was, it only happened because he was written off a bad debt to a builder.
I understand that. Sorry, what I should do is I should probably nuance my answer a little bit.
Yep.
I was talking in terms of are they going to audit somebody, or are they going to be looking at this sort of stuff in terms of specifically ConDev, ProBuild, people who will go broke? Are they getting the creditors list and saying, well, better keep an eye on all those people? No, I don't think they're going to do that.
No.
Will they, when you go to put in your annual returns and things like that, they'll assess your annual return in the same way as they assess any other year.
Yep.
That might mean that if you don't have the asset there, because one of the things you have in relation to your MFR when you're talking about debts, you have to do your collectability analysis naturally. So if one of your assets is a trade debtor or something like that, and you don't have it the next year, then yes, they're going to have to apply it that way. Yeah. Sorry, I took that as a slightly different question. My apologies if I've.
No, all good.
Yeah, but no, your situation is quite right. I was speaking more in terms of audit and things like that.
Mm-hmm.
Okay, sorry, and I just have one more question that has come through. So if a project trust account was in place on a project when a company goes into liquidation, can the liquidators actually claw back the funds, which I think is obviously what you've covered before? So is there a loophole in the trust account framework that doesn't necessarily protect the subcontractors for the preferential payment?
No. Bottom line. For those who are unaware, just the 2-minute analysis is this: when you have the project trust account, the money goes into the project trust account from the principal. There's one account, but all the subbies have a beneficial interest in that money. What it is to the extent of their entitlement. Now it's a little bit complicated, but when that money comes out, that's not the contractor's money that's coming out. That's the subcontractor's money that's coming out. It's just being all put into one conglomerated account. Because the contractor doesn't own all the money in the account, it's not an asset of the contractor, and therefore paying it out won't trigger a situation where there's a preferential payment. It's a little bit more complicated than that, but no, if you've got money out of a project trust, we are comfortable at our end that you are not likely to be subject to a preferential payment claim.
That is good news. I know I spoke with a master builders representative last week, and they told me that there was a flaw in the system, and that even if a preferential payment has been made, that the subcontractors will still miss out for that, or can still be clawed back for that 6-month period. And I said, "Are you sure about that?" So
I mean, depends what he's talking about. I mean, look, there might that I'm talking in the ordinary course of how things operate. It's one of those things like any system. You can potentially war game a situation where somehow it might happen. I can't think of what that war game might be that suggests that might happen. So I'm fairly confident in the current situation. If ProBuilder had been operating a project trust account, the money, at the very least, the last money that was paid out would be okay. So I'm comfortable in saying that.
Yeah, and that's the whole reason that we've been advocating for the implementation of these project trust accounts, to protect subcontractors' money. Mm-hmm. So, yeah, that's
sort of operates. It operates in the same sort of theory as the Subbies Charges Act, because what you are doing is you are getting the money through your security interest as a secured creditor. That money is yours. You own it beneficially. It sort of operates the same sort of mindset.
Yeah, that's good to know. Thank you. I know we're almost close to time, but does anybody have any questions or anything else they'd like to ask?
Actually, I've got a quick one for Brent.
Yes.
You sort of touched on it, well, you almost touched on it, I should say, before. We get a lot of anecdotal comments made by members or plumbers, and it doesn't matter if it's either in conversation or you see it a lot online, actually. The legal ramifications of, let's say I put a water heater in at Mrs. Smith's house, I've installed it.
Yeah.
And Mrs. Smith refuses to pay my bill. How long am I going to jail for when I turn up and take it out again?
How long are you going to jail for? Couple of things. One, yes, you are committing an offence because you've put it in. It's now part of the land. Couple of things. One, Mrs. Smith can sue you for trespass. That's the number one. So you've got a damages claim there, which you'll be putting in a new water heater, probably. In our example, the second one is you've committed a criminal offence because you've come and destroyed some of her property. What's the cost of that? Probably in your case, or in our example, a kick in the backside, I would have thought, because I think your average copper is going to say, "Are you kidding?" I've got actual crime to look at here, and more importantly, I've probably got some COVID notices to hand out. If perchance the answer is that the copper just wants it to go away, I suspect what your client's going to end up, what the plumber's going to do is end up writing a grovelling apology to Mrs. Smith, say, "Oh, I'm terribly, terribly sorry," and that'll placate the thing. Push comes to shove, I haven't even looked at what that penalty might be criminally, but it's not going to be a great deal beyond a kick in the backside.
Okay.
Can I just make one point though? Anytime you have a licensing regime, you want to be really careful about doing things that are potentially criminal in nature, because a lot of them, and I haven't thought about how that charge might interrelate with fit and proper. But I suspect the answer is it might be something that might be relevant to you your renewal in your next year, because you have been committed, you have stood trial for a criminal offence, so to speak, and it was related to your business. So, I mean, again, whether or not somebody can take your license off you for being a pain in the backside like that, I don't know. But my larger concern about the NBN guy in South Australia, he got himself some real trouble. I suspect not because of, it wasn't a small matter. He took out a lot of electrical cable. He basically took the NBN code down for a couple of days. So annoy a government instrumentality, and I can guarantee that the kick up the backside will be a lot swifter than Mrs. Smith down the road.
Right.
I suspect.
No, well, that's good. Look, it's always been the understanding that it's not legal to do that and all that sort of thing, but a lot of people think it is.
Oh no, I absolutely believe it. That glass contractor I was talking about, his solicitor wrote to us and said his client was going to come and take it. And I pointed out to him, were you missing that day in property law when we were explaining fixtures and chattels? You felt a bit sorry because you knew the lawyer. And I'm going, you might have missed the point here, mate. But look, you've just got to be so careful. And that's why you need to get this stuff right at the beginning, because you need to have as many tools in your toolbox as you humanly can. Because the reality is, the nature of the industry, you are not going to escape this. It is like COVID. Everybody's going to get infected by this at some stage or another. It is going to affect you, so you might as well figure out how to deal with it and get immunised early.
Fair enough. Thank you.
Yeah, that's some very good points there. Thank you.